now like to turn the call over to our host, Ms. Mariela Malero. You may begin.
Well, thank you very much, operator, and thank you all for joining us this afternoon. We are indeed going to be taking a number of calls after a brief introduction from our director, Alejandro Mayorkas. Ali, the call is yours.
Thank you very much, Mariela, and thanks to all of you for joining today. Really, the purpose of this call is to provide you with updated information with respect to the process that we have developed for the receipt of requests for deferred action. I do want to review some of the information that we provided in our first conference call, should there be participants today that did not have the opportunity to participate on June 18th. Over the past 3 years, the administration has undertaken an unprecedented effort to transform our immigration enforcement system into one that focuses on public safety, border security, and the integrity of the immigration system. As the Department of Homeland Security continues to focus its enforcement resources on the removal of individuals who pose a danger to national security or a risk to public safety, including individuals convicted of crimes with particular emphasis on violent criminals, felons, and repeat offenders, DHS will exercise prosecutorial discretion as appropriate to ensure that enforcement resources are not expended on low-priority cases. As a further step, on June 15, 2012, the Secretary of Homeland Security announced that certain people who came to the United States as children and meet several key guidelines may request consideration of deferred action for a period of 2 years, subject to renewal, and would then be eligible for work authorization. To implement the Secretary's memorandum, U.S. Citizenship and Immigration Services, or USCIS, is creating a new process for individuals who meet these guidelines to request consideration of deferred action for childhood arrivals. Deferred action is a discretionary determination to defer removal action of an individual as an act of prosecutorial discretion. It does not provide lawful status or a pathway to permanent residence or citizenship. In addition, deferred action does not excuse individuals of any previous or subsequent periods of unlawful presence. Under existing regulations, an individual who receives deferred action and demonstrates economic necessity for employment is eligible to also receive employment authorization for the period of deferred action, and in this case, that is 2 years. Individuals who demonstrate that they meet the following guidelines may request consideration of deferred action for childhood arrivals from USCIS. USCIS will make its determination on an individualized case-by-case basis. Beginning August 15th, and not before then, individuals may request consideration of deferred action for childhood arrivals if they, 1, were under the age of 31 as of June 15, 2012, 2, came to the United States before reaching their 16th birthday, 3, have continuously resided in the United States since June 15, 2007, up to the present time, 4, were physically present in the United States on June 15, 2012, and at the time of making their request for consideration of deferred action with USCIS. 5, entered without inspection before June 15, 2012, or their lawful immigration status expired as of June 15, 2012. 6, are currently in school, have graduated or obtained a certificate of completion from high school, have obtained a general education development or GED certificate, or are an honorably discharged veteran of the Coast Guard or Armed Forces of the United States, and 7, have not been convicted of a felony, a significant misdemeanor, or 3 or more other misdemeanors and do not otherwise pose a threat to national security or public safety. I would like to, if I may, clarify some of the guidelines I just outlined. First, with respect to age. If an individual has never been in removal proceedings or the proceedings have been terminated prior to the request for deferred action, the individual must be at least 15 years of age or older at the time of filing their request. If they are in removal proceedings, have a final order, a removal order, or have a voluntary departure order, and are not in immigration detention, they can request consideration of deferred action for childhood arrivals, even if they are under the age of 15 at the time of filing their request. In all instances, they cannot be the age of 31 or older as of June 15, 2012, the date of the Secretary's memorandum, to be considered for deferred action for childhood arrivals. Second, the guideline with respect to travel. A brief, casual, and innocent absence from the United States will not interrupt the continuous residence guideline as long as it was before August 15, 2012. After August 15, 2012, if one travels outside of the United States, one will not be considered for deferred action under this process. If an individual receives deferred action in their case and they want to travel outside the United States, they must apply for advance parole by filing a Form I-131 application for travel document and paying the applicable fee, which is $360. USCIS will determine whether the purpose for international travel is justifiable based on the circumstances described in the request. Generally, USCIS will only grant advance parole if the individual is traveling for humanitarian purposes, educational purposes, or employment purposes. They may not apply for advance parole unless and until USCIS determines whether to defer action in their case pursuant to the consideration of deferred action for childhood arrival process. An individual cannot apply for advance parole at the same time as they submit a request for consideration of deferred action for childhood arrivals. With respect to the guidelines regarding school, to be considered currently in school under the guidelines, individuals must be enrolled in school on the date they submit a request for consideration of deferred action under this process. Let me, if I can, spend a few minutes on documents and evidence. Documentation to demonstrate that an individual came to the United States before the age of 16, has resided in the United States for 5 years immediately preceding June 15, 2012, and was physically present on June 15, 2012. 2012 includes, but is not limited to, financial records, medical records, school records, employment records, and military records. Documentation to demonstrate that an individual is currently in school, has graduated from high school, or has obtained a GED certificate includes, but is not limited to, diplomas, GED certificates, report cards, and school transcripts. Documentation to demonstrate that an individual is an honorably discharged veteran of the Coast Guard or Armed Forces of the United States includes, but is not limited to, report of separation forms, military personnel records, and military health records. Affidavits generally will not be sufficient on their own to demonstrate that an individual meets the guidelines for USCIS to consider them for deferred action for childhood arrivals. However, affidavits may be used to support meeting the following guidelines only if the documentary evidence available is insufficient or lacking. 1, a gap in the documentation demonstrating that an individual meets the 5-year continuous residence requirement, and 2, a shortcoming in documentation with respect to the brief, casual, and innocent departures during the 5 years of required continuous presence. Circumstantial evidence may be used to establish the following guidelines and factual showings if available documentary evidence is insufficient or lacking and shows that the individual was physically present in the United States on June 15, 2012, came to the United States before reaching his or her 16th birthday, satisfies the 5-year continuous residence requirement as long as the individual presents direct evidence of continuous residence in the United States for a portion of the required 5-year period, and the circumstantial evidence is used only to fill in gaps in the length of continuous residence proven by the direct evidence, and any travel outside the United States during the 5 years of required continuous presence, that it was brief, casual, and innocent. Additional information about what documentation can be submitted will be provided on the USCIS website on August 15, 2012. Information provided in an individual's request is protected from disclosure to U.S. Immigration and Customs Enforcement, that's ICE, and U.S. Customs and Border Protection, commonly known as CBP, for the purpose of immigration enforcement proceedings, unless the requestor meets the criteria for the issuance of a notice to appear or a referral to ICE under the criteria set forth in USCIS's Notice to Appear guidance. That guidance is already published in effect, and it may be accessed at www.uscis.gov/NTA. That's www.uscis.gov/NTA. Individuals whose cases are deferred pursuant to the consideration of deferred action for childhood arrivals process will not be referred to ICE. The information may be shared with national security and law enforcement agencies, including ICE and CBP, for purposes other than removal, including, for example, for assistance in the consideration of deferred action for childhood arrivals, to identify or prevent fraudulent claims, for national security purposes, or for the investigation or prosecution of a criminal offense. This information sharing policy covers family members and guardians in addition to the requester, him or herself. I should indicate that this policy, which may be modified or superseded or rescinded at any time without notice, is not intended to and does not and may not be relied upon to create any right or benefit. If I can now share information with respect to the filing process specifically. Beginning August 15th, 2012, and it is important to emphasize not before then, but beginning August 15th, 2012, individuals will be able to submit a request for consideration of deferred action to USCIS through a new form, together with a second form requesting an employment authorization document. Individuals meeting the guidelines who are not in detention will affirmatively request consideration of deferred action for childhood arrivals from USCIS through this process. This includes individuals in removal proceedings with a final removal order or with a voluntary departure order. Please note, if I may, that now individuals in removal proceedings will be making their request of USCIS and not ICE. The only individuals who will seek a review of their case from ICE will be those currently in detention. Requests will be filed at the USCIS lockbox. They'll be mailed to the USCIS lockbox and will be reviewed at all 4 USCIS service centers. The total fees will be $465. USCIS is still developing the forms and will be submitting them to the Office of Management and Budget, OMB, for review. Pending OMB clearance, the forms and instructions will be available on the USCIS website on August 15, 2012. Any request received before August 15, 2012 will be rejected. There are no fee waivers available for the deferred action for childhood arrivals process. There will be fee exemptions available if individuals can demonstrate they, one, are under 18 years of age, are homeless, in foster care, or otherwise lack any parental or other familial support, and their income is less than 150% of the U.S. poverty level. Or they cannot care for themselves because they suffer from a serious chronic disability and their income is less than 150% of the U.S. poverty level. Or they have, at the time of the request, accumulated $25,000 or more in debt in the past 12 months as a result of unreimbursed medical expenses for themselves or an immediate family member, and their income is less than 150% of the U.S. poverty level. The fee exemption process, people who pursue that will need to request the fee exemption in advance of the request for deferred action through a separate process, and we will, of course, have more information on that. The fee exemption request must be submitted and decided before an individual submits their request for consideration of deferred action for childhood arrivals without a fee. And I should note that the request for exemption also cannot be submitted before August 15th. After a request has been received by us, by USCIS, individuals will then be scheduled for a biometric services appointment, and we will be subject to background checks against a variety of databases maintained by DHS and other federal government agencies. USCIS will then make its determination of whether to exercise prosecutorial discretion in the individual case. Individuals will be able to track the progress of their deferred action request online. If USCIS denies the request for consideration of deferred action for childhood arrivals, individuals cannot file a motion to reopen or reconsider and cannot appeal the decision. USCIS will not review its discretionary determinations. USCIS we will implement this process in a manner that ensures the integrity of the immigration system. Individuals who have been convicted of a felony offense, a significant misdemeanor offense, or 3 or more other misdemeanor offenses will not be considered for deferred action under the new process. A felony is a federal, state, or local criminal offense punishable by imprisonment for a term exceeding 1 year. A significant misdemeanor is a misdemeanor as defined by federal law, specifically one for which the maximum term of imprisonment authorized is more than 5 days, but less than 1 year, that, regardless of the sentence imposed, is an offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or driving under the influence. If not an offense noted above, if not an offense in one of those categories, is one for which the individual was in fact sentenced to time in custody of more than 90 days. A non-significant misdemeanor is any misdemeanor as defined by federal law that is not an offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or driving under the influence, and is one for which the individual was sentenced to time in custody of 90 days or less. It is important, I think, to emphasize that driving under the influence is a significant misdemeanor, regardless of the sentence imposed. A minor traffic offense will not be considered a misdemeanor. As a matter of discretion, a requestor's entire offense history will be considered along with other facts to determine whether, under the totality of the circumstances, they warrant an exercise of prosecutorial discretion. If the case does not involve a criminal offense, fraud, or a threat to national security or public safety, it will not be referred to ICE for purposes of removal proceedings, except where DHS determines there are exceptional circumstances. If an individual knowingly makes a misrepresentation or knowingly fails to disclose facts, they will be treated as an immigration enforcement priority to the fullest extent permitted by law and be subject to criminal prosecution and or removal from the United States. Let me, if I can, make a few final comments about the unauthorized practice of immigration law, commonly known as notario fraud. We are very concerned about the risk of immigration scams and unscrupulous practitioners who seek to take advantage of the population of young people who may request deferred action through the process I have described. There is no expedited processing for deferred action and no cost to obtain USCIS forms or other information. Dishonest practitioners may promise to provide individuals with faster services or special access for a fee. People should be wary of these scams. We have information and resources to educate the public on how to avoid immigration services scams. Allow me to provide you with the website where that information and those resources are described. The site is www.uscis.gov/avoid-scams. Again, that is www.uscis.gov/avoid-scams. One should make sure that one seeks information about the Deferred Action for Childhood Arrivals process from official government sources such as USCIS or the Department of Homeland Security, or find a licensed attorney or accredited representative. We have a listing available on our website. Allow me, if I can, to provide you with 2 additional contact points for information about this process. We have a website at www.uscis.gov/childhood arrivals. That's www.uscis.gov/childhood arrivals. The website will include frequently asked questions that have just been updated, a flyer to provide an overview of the Deferred Action for Childhood Arrivals process, and a How Do I guide for the Deferred Action for Childhood Arrivals filing process. We also have a National Customer Service Center with an 800 number for people seeking additional information. The National Customer Service Center number is 800-375-5283. That is 800-375-5283. I do believe that we have time for a handful of questions, if I may refer to the operator or Mariela to field those questions, and I'd be happy to answer them.
Thank you very much, Ali. And operator, as Director Mayorkas indicates, we will take a handful of calls, please.
If you'd like to ask a question, please press star then 1 on your phone keypad. And we do have some callers. The first one, Jason Gans. Your line is open.
My question is there a requirement that the person who's over 15 be actually in high school, or can they be in a lower class of school? And then the other question is, why was age 15 used to exclude people who would have met the program?
We will have, I appreciate the question, we will have more information with respect to the guideline of currently in school on August 15th, so that we will have more information out to the community at that time.
Our next question will come from Julie Dinnerstein. Your line is open.
Thank you so much. Thank you for this call. This is Julie Dinnerstein at Sanctuary for Families. My question goes specifically with respect to people in removal proceedings. So I understand that going forward, the procedure will be that people are submitting a form through USCIS. That's clear from your written materials and from your statements. And as you are aware, from June 15th until the present, there have been sort of a two-pronged procedures, or maybe three prongs, where people have been able to call an ICE number, an ICE public advocate number, and their case was assigned an individual tracking number. And people have also submitted requests to trial attorneys who have then, if they think it's an appropriate case, given it to ERO for deferred action. My question for consideration for deferred action is, if you have a case that was not already granted deferred action since June 15th, but is already somewhere in the process where the trial attorneys have signed off, where ERO may have the case, or where a tracking number has been initiated, for that group, what is the current instruction? And then one related question, which you may not know the answer to, because it may be outside of the CIS, is will people in removal proceedings be getting termination or administrative closure?
So I appreciate the question with respect to the process and specifically the change in that individuals in removal proceedings beginning August 15th will be making their request of USCIS. We thought that was the most efficient way to proceed, to really have a focused point of contact and for determination of the request for deferred action. Individuals who already have made their requests, who are in removal proceedings of ICE, their requests are under consideration now, and if there's any question with respect to the disposition of those requests, I would encourage an individual to reach out to the 800 number that ICE has provided through the Office of Public Advocate. Thank you very much.
Thank you.
Our next question will come from Yvette Sadek. Your line is open.
Thank you very much. I have a question with regards to people who have cases currently pending. Will this affect them in any way if they apply for deferred action?
When you say if a case is pending, in other words, they've already made a request of ICE since June 15th?
No, actually, for example, if a client is applying for a U visa, something that's already pending with immigration, will this affect them if they also apply for this as well?
I see. Thank you. So if indeed an individual has an application pending, but the adjudication of that application has not been communicated to the individual, then that individual can still make a request for deferred action under this process of USCIS. However, if the benefit sought through the application that already has been filed has been granted and the individual therefore has status, then the individual cannot request deferred action under this process.
Perfect. Thank you very much.
Thank you.
Operator, we will take 3 more questions, please.
Our next question will come from Paula Fitzgerald. Your line is open.
Hi, I have two questions. First of all, is it acceptable if they obtain the GED after June 15th? And then second of all, how long you expect the adjudication time will be?
I'm sorry, can you please repeat the question?
Sure. The first question was whether it's okay if they obtain the GED after June 15th of 2012. And the second was how long the adjudication time will take.
I see. So the important thing is that the individual be currently in school as of the date of the request. So they and with respect to the length of the process, that is going to be something that we are closely monitoring. That will depend upon the volume, not only the volume of requests that we receive, but the pace at which we request them. We understand the importance of this program.
So they can obtain the GED as long as they have it before they apply, it sounds like you're saying?
Yes.
Okay. Great, thank you.
Our next question will come from Francisco Chavez. Your line is open. Mr. Chavez, please check the mute button on your phone. Our next question will come from Jose Alfredo Hernandez.
Good morning, sir. Attorney Jose Alfredo Hernandez here. I have a series of couple questions, and the first question is, the fee that you said included was $465. That includes the employment authorization?
Yes, the $465 fee covers the request for deferred action for childhood arrivals in totality.
Got it. Second part question to that was, how long will the EAD be issued for? Will it be issued for the 2 years that the deferred action is granted?
Yes.
Okay. And my final question is, the adjudication. Nowhere in your brief stated of an interview. That's correct? It'll just be decided by USCIS?
If you ask whether interview will be a part of the process, an interview will not be required as part of the process. However, interviews will be used for discrete purposes to ensure the integrity of the process. So, for example, if there is a concern with respect to fraud, an interview may be required to address the concerns.
Thank you, sir. Final question. Is there a renewal fee for this?
I'm sorry, it may also be used as a quality assurance mechanism.
Got it, sir. And the final question was, sir, after the 2-year period of deferred action is completed, will there be a renewal fee?
Yes, there will. The individual who receives deferred action, the receipt of deferred action will be subject to renewal for a period of 2 years with a commensurate fee. And I'm gonna, if you don't mind, allow your 4 questions to stand at 2 and move on to one last individual.
Thank you, sir.
Our final question will be Jordan Forsyth. Your line is open.
Thank you. I'm curious if no operator's license offenses in particular are considered minor traffic offenses.
We will have information posted publicly on August 15th with greater specificity on those issues. I appreciate the question.
Thank you.
Again, allow me to thank everyone for joining our call this afternoon. Let me reiterate that on our public website, we have additional materials that have been updated to cover the information that I addressed on the call just now, as well as additional information. We have frequently asked questions. We have a guide for individuals, the How Do I guide for filing, and we have a flyer to provide an overview of the process. Those materials are available at our website, uscis.gov/childhood arrivals. Thank you all again, and thank you, Mariela and operator.
Thank you very much, Ali. Thank you so much for joining. And I also wanted to remind all of you that we also have a 1-800, as the director mentioned earlier, and that is 1-800-375-5283. Thank you very much for joining us this afternoon.
Thank you for your participation on the conference call. At this time, all parties may disconnect.